Texas is the only state in America where your employer can choose not to carry workers' compensation coverage, the only one. And in the oil fields, where injuries can be extremely severe and employers hold a lot of power, 1 in 3 employers choose not to have workers' compensation coverage. These employers have chosen to opt out of that program. I'm Max the Axe, the gold standard in personal injury. And if you've been hurt in the oil field, everything about this case is different. These cases are unique when it comes to the injuries, the insurance, the parties, and the special rights that you have as the injured person. And as for the company that said that they're going to take care of you, they've already started building their defense before you ever get out of the emergency room. Why oil field injuries are in the category of their own. Oil field work is some of the most dangerous work in the United States, and the injuries reflect that reality. Severe burns from blowouts or flash fires, crush injuries from equipment failure, falls from derricks or platforms, traumatic brain injuries from falling objects, chemical exposure that may not show symptoms for years, amputations, spinal cord damage. These are not fender bender kind of injuries. These are catastrophic, life altering injuries that people have to deal with permanently. The CDC reports that Texas leads the nation in oil field fatalities, making about 40% of all oil and gas fatalities in the year. And according to the federal data, oil field workers are 7 times more likely to die while working compared to the average worker. Now, here's what makes these cases legally different. Usually, when you get hurt on the job here in Texas and in many other states, your only remedy is workers' compensation. And this kind of situation is usually not good for the employee. You go through the claims process, you file a claim, you go to the special workers' comp doctors who tell you that you're all better and you don't need that much medical treatment. You get a fraction of your wages and your medical bills paid, but overall, you cannot sue your employer, you cannot get anything for your pain and suffering, physical impairment, or mental anguish caused by these devastating injuries. But in Texas, where workers' compensation is optional and your employer chooses not to carry workers' comp, the odds are actually now in your favor. When this happens, the legal landscape changes completely, something that most workers in the oil fields and elsewhere do not know or understand. So here's what you need to know immediately after an injury like this. Does your employer carry workers' compensation insurance, or are they considered a non-subscriber? Now, it's important that you know exactly the name of the insurance that they carry, because there are many other insurances that sound like workers' comp, but actually is not. There are things like work injury insurance, disability insurance, liability insurance. Those things are not workers' compensation. It has to be called workers' compensation. And if your employer does not carry this type of insurance, then they are considered a non-subscriber. And as an injured worker, you're actually hoping that your employer does not carry workers' compensation insurance, because then you can collect for your pain and suffering, physical impairment, mental anguish, and other damages that ordinarily would not be available for you if your employer was carrying workers' compensation coverage. Non-subscriber employers, the Texas law that changes everything. If your oil field employer opted out of workers' compensation coverage, they are considered a non-subscriber. And under Texas law, a non-subscriber employer can be sued directly for the injuries that you sustain while on the job. And here's the trap for them. When an employer opts out of workers' compensation coverage, they lose 3 main defenses that would ordinarily be available to them. One of the legal defenses that they lose is called contributory negligence. In other words, where they argue that you were partly at fault. Another legal defense that they lose is called the fellow servant rule. In other words, it's the coworker's fault, not the boss. They can't make that argument either. And finally, they can't argue something that's called the assumption of risk, which means, hey, you knew what you were doing when you were doing it. You knew that it was risky. You knew that the job was risky, and you assumed the risk when you took this job. They can't make any of these arguments. So without those defenses, the only argument the employer can make is that they were not negligent at all, 0%. And with these kind of oil field injuries, you often find safety violations that are well documented, training gaps where people are not properly trained, and maintenance logs for the equipment that shows that they weren't properly maintained. When you have this kind of evidence, it's very easy to prove negligence on the employer. Let me tell you about Ray. He's a tough guy working on a drilling rig out in the Permian Basin. While he was working, a cable snapped, which hadn't been inspected in months. As a result, Ray lost 3 fingers, but his employer was a non subscriber. Ray filed a lawsuit, and because the employer was a non subscriber, they had very few legal defenses to try to argue against their own negligence. If you're not sure whether your employer has workers' compensation coverage or is a non subscriber, you can always check it online. If you go to the Texas Department of Insurance Workers' Compensation Division, you can actually search the name of your company and you can see if they are listed as a non subscriber. Your attorney can pull this kind of information within the first few minutes of talking to them. So here's what you need to confirm whether or not your employer is considered a non subscriber or, in fact, does have workers' compensation coverage. The answer to that really shapes a lot of your legal strategy. Third party liability. You may be able to sue more than your employer. Oilfield operations often involve multiple companies working at the site at the same time, and any one of them may be liable for your injuries. First, equipment manufacturers. If a piece of drilling equipment was improperly designed or manufactured, the company that made it may be liable under product liability law. And that's true regardless of what your employer did or didn't do. General contractors and site operators. If the company managing the drilling site failed to enforce safety protocols or maintain the equipment or provide adequate training to the workers, they may also be a defendant in a claim. Landowners. The entity that owns the mineral rights to the land may also have additional obligations regarding site safety. And here's what a lot of people miss. Your lawsuit against a third-party entity does not affect your workers' comp claim at all. Workers' comp is between you and your employer. However, a separate lawsuit involving a third party is completely valid as long as the person you're suing is not your employer directly. So you can collect workers' comp benefits while also simultaneously suing a negligent third party for additional damages. And these additional damages include pain and suffering, physical impairment, and mental anguish, among others. These kind of damages are not covered by workers' compensation. The most sophisticated oil field injury lawyers investigate the site and identify every single entity that was involved. Anyone who touched the job site, the equipment, or the safety protocols. All of these people may be entities of interest. Identifying all liable parties is the most important thing to maximize your claim when it comes to these catastrophic injuries that happen on oil fields. So here's what to demand from your attorney: a full-scale investigation into every contractor, every equipment provider, and every site operator involved in your accident. What the company does after you get hurt. The moment an oil field accident happens, the company's response team activates, and their first priority is not your well-being, it's their liability. They will be investigating the scene. They will be taking photographs. They will be doing interviews with your coworkers. They will document the equipment. They will build a narrative that minimizes their exposure and their liability. And this often starts taking place before you ever leave the hospital. And here's the trap. Many companies will send a representative directly to you. They may ask you to sign documents. They may ask you to give a recorded statement about exactly what happened. Everything you say and do during this period can be used against you later. Some companies will even condition your paycheck upon you signing a waiver. They may hold your wages hostage until you sign a letter that waives away all of your rights. But under Texas law, these kind of tactics are challengeable, but you need to have a qualified personal injury attorney who knows what he or she is doing to fight back against these tactics. And here's what the company doesn't tell you. While they're visiting you in the hospital and expressing sincere signs of concern about your well-being, they're actually at the same time mounting a defense that holds you 100% responsible for all of your injuries, and the company completely scot-free for doing anything. They will say that you caused the accident yourself, that you were not following proper safety procedures. They will argue that you were properly trained, but instead you ignored protocol. Now, the evidence to disprove their legal arguments, it exists. It's out there. It's in training records, equipment logs, OSHA inspection histories, and coworker testimony. But this kind of evidence must be preserved and obtained quickly before the company has time to revise it or lose it. Here's what to preserve. Do not sign anything without speaking to an attorney first. Do not give a recorded statement. Document all of your injuries and keep your own records. Why oilfield cases have high settlement values. Oilfield injury cases often have some of the highest settlement and verdict values in all of personal injury law, and there are very specific reasons for this. First is that the injuries are often catastrophic. Burn injuries often require years of medical treatment. Amputations can end your professional career. Spinal cord injuries often require lifelong care. Brain injuries can change your personality and your function permanently. These are not cases where someone simply misses a week of work. These are cases where the injured worker's entire life trajectory changes. The negligence is often well documented. OSHA requires very detailed safety records for the oil and gas industry. And when those records show violations, whether it's skipped inspections, expired certifications, or ignored maintenance schedules, the evidence of negligence is built into the company's own paperwork. And finally, the defendants often can pay. Oil and gas companies, equipment manufacturers, and site operators often have substantially large insurance policies. When liability is clear and the injuries are severe, the financial capacity to pay these significant injury damages are there. I've seen oil field injuries regularly resolve for seven figures and a whole lot more. But those results often depend on one thing. How quickly can you get your attorney involved to preserve evidence, investigate the scene, and identify all the proper parties? And you have to act quickly before the company's legal team starts controlling the narrative. So here's what you have to understand. The value of your case often depends on acting fast, documenting every part of the process, and identifying every liable party. If you were hurt in the oil field, don't assume that workers' compensation is your only option. It may not even be the best option. And if your employer is a non-subscriber, you may have rights that are far more powerful than you can imagine. If you've been injured in an oil field accident, call my office today for a free consultation. It can be one of the most important phone calls that you make. And be sure to watch my next video on Texas non-subscriber employers so that you can fully understand how the law protects injured workers. I'm Max the Axe for Lone Star Injury Attorneys. We fight for injured Texans.